Nine-judge Constitution Bench of the Supreme Court reserved judgment on Wednesday on the question whether material resources created by individual human labour would constitute the resources of the community. Now, this hearing was by a bench that was headed by the CJI, D.Y. Chandrachud, and it fundamentally was centred around the contours of Article 39B of the Indian Constitution, and it discussed, it was looking at whether privately owned resources could be considered material resources of the community. Now, I have my colleague, experts Khushbu Jain and Kapil Sankla joining us to understand the fallout of, to understand why this issue is even being discussed. Let me go across to Mr. Sankla. Sir, India is a country that's talking about being a welfare state, but we also are highly dependent on private investment. Tell us, how is the court looking at this particular issue, and when the AG says that all things in the material world which are available and made available by human interaction or engagement constitute the material resources of the community, what would that mean, and what would the CGI would want us to interpret when he says that resources created by corporations such as semiconductor chips are all resources of the community?
Very interesting question, and it has some historical background that I'd like to tell you. You see, historically, a person's property is not a person's property absolutely, and the government can take it under certain situations. For example, you have land acquisition. You have land acquisition for private parties. You also have, for example, the government saying that we need to create a passage here, a road here, a bridge here, and can take over private property. I mean, that's there, that's settled law. Then this particular facet was kind of enlarged in various cases where the government then took over temples or private properties or private organizations. The case to point, one of the most famous cases is the Pondicherry case, where Auroville was taken over by the government. So there is historical background to the government having a right over your private property. Then came situations like COVID and certain other situations where the government said, and this is also one of the fundamental questions that the government is fighting with international community as far as patents is concerned, pertaining to generic drugs, saying that if it is required for private community, therefore you cannot have an absolute right, even an IPR or an intellectual property right, which is supposed to be sacrosanct internationally. So in the light of the same, what was argued by the government is on basis of historical facts. And what was therefore, and to answer your question, what was replied to or reverted to or observed by the bench was that, listen, you want to bring in private players to India, and those private persons come over and set up shop, and then tomorrow you say for XYZ reason we are taking over your IPR or your what you've created and all of that for community good. That cannot be. What is going to happen is that no international player will come to India. So there's a dichotomy. There are two very extreme points of view here. But there is one point of view which goes as far as the historical powers of the government is concerned, and also your fundamental rights are not absolute, and the directive principles are only guiding principles.
Right.
So, I mean, this is one fact of it. The other fact of it is that as far as IPR is concerned, the courts in India have held that to be sacrosanct, and therefore the right of an individual has now to be tested and protected, vis-a-vis also the right of the community that also needs to be tested and protected.
Okay. Khushbu Jain, when the Supreme Court says that Article 39B shouldn't be read like there is no protection for private rights, what does it mean for a welfare state like India that is also relying on private investments? Because there are very interesting observations specifically with regard to semiconductors. There's in fact, one thing that the CGI says that a plot could be owned by a private individual and a road could be built on that, because that basically looks at community service, or that looks at the interest of the community. But how do we read this Article 39B, which is in some ways become central to this entire hearing?
See, if you are asked to understand Article 39B, it is nothing but it makes it obligatory for the state to create policy towards securing that the ownership and control of the material resources of the community are distributed best to serve the common good. Now, the whole parlance comes here is the common good. So the test of what is common good and what do you mean by the interpretation as to the as to for the community, what is for the community. That's where, the material resources for the community, that's where the whole interpretation would lie, and that's where we are standing today. And that's where Article 39B Constitution, which was being created at the time when Constitution was being enacted, and today would be seen in a very different manner. And that's why we are standing today, that I do have a private property rights. If I'm owning the property, there, as rightly said by you, that there are investments, foreign investments done in India. Looking at that, and if this kind of thing comes in play, where exactly do we stand? We are at the place where we talk about development. We are no more in that communism and socialism, which was 60 years back or 70 years back. But today, where we are standing, we are talking about progressive state. We are talking about investments coming from all over the world. So will this stand in between those investments, those aspects where we are growing? So that's where the interpretation come, and the interpretation that it cannot be absolutely taken away. If you'll see, the court has taken up both the views, that it cannot be that the state doesn't have a right at all, because the whole aspect of the state is to look into that, to take care of the common good. So that common good aspect also cannot be taken away, but at the same time, it cannot infringe into somebody's right to private property, that you and me have created something, with the
Right.
sweat and blood, and that's not taken away. So that's where I think the whole interpretation is going on, that what exactly and
Right.
how that continue as an interpretation, or which bracket will fall more strong. But at the same time, the judgment, which is the Maharashtra Act, which was the policy which was been there, I think they are taking that stand separately, irrespective of what 9-judge bench as a constitutional interpretation to this will come in place.
Coming to that, Mr. Sankla, Gopal Sankar Narayanan made an important point. He said that the 9-judge bench needs to answer only the limited question referred to it and leave the rest to be dealt with by different benches at different times, as and when situation arrives. The CJI, of course, has said that if we assume that all private property consists of material resources, there is nothing left for future benches. And like Khushbu was also saying, we know that we already have a case in which the Maharashtra government has told Supreme Court that material resources of community would also cover private resources. What are the precedents of courts hearing this matter, sir, and what have been the understanding when it comes to their observations and judgments?
See, with all due respect to the senior counsel, there is one difficulty in what he wants. I mean, what he wants holistically sounds right. But the dispute you will have tomorrow is that judges are also human beings, and their interpretation of law also is, is hammered through the years of experiences that they have. So you cannot have an inconsistent judgment from one state to another state as far as what is private property and what is the government's right as far as this private property. So the consistency can only be laid down by this judge. So this bench. So I think what the bench is going to do and what the government wants holistically seems to be correct, because they're both arguing or setting forth points which are miles apart, and therefore the judgment would come now looking at both these issues holistically. That is one. Secondly, we also have to understand that Minerva law judgment of 1980 is still a good law. And in that judgment, the Honorable Supreme Court made two very important observations. One said that, listen, we can always call into question whatever the government does. You cannot say that under certain aspects of the law, we cannot question, challenge, or open up any decision that you've made. So that is one. This is important. The second was even more important, where they stated that the directive principles will have precedence over the fundamental right. Because if they would have done that, then the whole issue of that the fundamental principles are sacrosanct would have been thrown out. Right. So therefore, if we go by the judgment, which is still a good law, the directive principles are only that, directive in nature.
Right.
They cannot go over and take over your fundamental rights. Having said that, the larger interest also has to be protected, which the government has also done, as I told you, in the IPR issues pertaining to generic drugs.
Right.
So this is where we are. So interesting time to see what the decision is.
Khushbu Jain, very basic question. Yesterday in this hearing also, the council seems to have cited this example of a businessman setting up a vaccine manufacturing facility, and he has said that, it may have been purely private resource at that time, but then COVID came and then it becomes something that's essential for the entire community, and then the state has to step in. Help us understand, is it even possible for the government to redistribute privately owned property? And this is also becoming a political flashpoint in a parallel universe, because elections are going on, and Rahul Gandhi's promise of wealth redistribution has also become a controversy now.
No, that would be an extreme to go ahead with, that, you go for wealth redistribution. But that's where I'm again saying that the aspect to understand what is public good and what will constitute that will something which will play a very important role over here. Because if you'll see absolute interpretation of Article 39B, if you'll see, it was been crafted or it was been introduced in the Constitution for the aspect, for the purpose, because it wanted to bring in a social transformation. So you need to understand that the moment private property is a private property, absolute private property, and the government doesn't have any interference at all, there would be no application or there would not be any requirement of Article 39B at all. So that has to be struck down. But again, I'm going on that thin line that both the things are necessary, the aspect of public good, but it cannot be a blanket thing that what exactly do you mean by a public good, or does 39B give an unprecedented or non-curtailed power to the government to interfere in anything and everything. But if you look into the COVID times, it was necessary, it was required. It's my personal interpretation. I'm not getting into that aspect. But I think all of us would agree that that was something which was required for the larger public good, because it was not affecting one or two, but it was affecting everybody at a large. So aspects like this, I think it's very necessary that we need some power for the state, because we need a state to take care of certain state to take care of its citizen. And when you talk about public good, I think that interpretation of public good is something which is very important. And I think there are judges who have been talking about understanding of public good, and I think we should wait and watch what exactly comes of an understanding or interpretation of public good. But I would say any government that comes in power should understand and should exercise this public good and 39B in a very restricted, calculative and absolute need basis only.
Right. Thank you, Khushbu Jain, and thank you, Mr. Sankla, for joining us. As wealth redistribution dominates political news headlines in India, the Supreme Court has reserved its judgment after hearing an unrelated case about whether the government can acquire and redistribute privately owned properties if they are deemed as material resources of the community. Several interpretations and factors at play here. We'll keep tracking that for you.